Good morning.
How are you today?
Good morning. A little nervous.
Okay. Well, as she said, I'm going to read some identifying information into the record, ask you to confirm it. And then your case has been assigned to Mr. Marabella, so I'll turn it over to him after that, and you'll be answering his questions. So you are Dawn Hargrave. You're classified as a first felony offender. Your DOC number is 492910. You're here seeking a commutation of your sentence. You were sentenced in Vermilion Parish in 2005 to a life without parole sentence for a second-degree murder conviction. Is that information correct, Ms. Hargrave?
Yes, ma'am.
All right. Would you answer Mr. Marabella, please?
Good morning, Ms. Hargrave. How are you? My name is Tony Marabella. Your case was assigned to me, so I'll be the first one to conduct the interview with you. Can you hear me okay?
Yes, sir.
Ms. Hargrave, how old are you, ma'am?
I'm 50.
Okay. And how long have you been in prison on these charges or in jail? How long have you been incarcerated?
This year will make 20 years.
Okay. Tell me a little bit about your educational background. How much education have you had?
I graduated high school on the streets, and here I've received an upholstery diploma, an IC3 diploma, and several NCCR certifications.
Okay. Tell me a little bit about your NCCR certifications. What are your certifications in?
I'm certified in basic safety. I can proctor. I could teach them. I can performance evaluate them in plumbing level 1, cabinet making, electrical level 1, and core safety.
Had you had any of those skills before you came to prison?
I hadn't been certified in it. I had just learned how to work on things by being raised with my grandfather and certain jobs, just general maintenance.
In reviewing your record, it's also my understanding that you've been a tutor to various inmates in various subjects. Tell me a little bit about that.
Yes, sir. I tutor in all those subjects. I also tutor in upholstery, and I facilitate RDAB, which is a residential drug abuse program in the reentry court program. Here, I'm a mentor.
And how long have you been doing that? How long have you been a mentor in the REDAP program?
I've volunteered since it started in 2015, but I've been classified as a mentor for, I think in 2018, I was classified in there.
Okay. What jobs have you held while you've been in prison?
Maintenance for nearly 10 years. Snack Shack, which is offender orgs. We had a store and kitchen where we would cook. Upholstery tutor, mentoring. I was a groundskeeper on outer perimeter. Keep taking care of the grounds on outer perimeter. I've been a floor worker. I've did almost all the jobs that LCIW has to offer.
Okay. In reviewing your documentation and in noting some of the reports that we have here, you indicated, and I believe it was you that indicated to the persons who were doing the interviewing, that you used heroin, pain pills, cocaine, and alcohol daily from 1987 to 2002. Is that a fair statement? Is that accurate?
Yes, sir.
Okay. Tell me when you started using drugs and alcohol. What age were you?
About the age of 13.
Okay, and what did you start using?
I started drinking and then pills, and it just progressed throughout the years.
How old were you when you started using heroin and pain pills and cocaine on a regular basis, on a daily basis?
Oh, that was probably in 2000, 2001. It really got bad in 2001 when I got hurt on my job, and that's when I really got hooked on the pills, because they was giving me pills because I had neck surgery.
And you consider yourself to be a drug addict?
Yes, sir.
Now, let's talk a little bit about the offense that you find yourself in prison for, the murder. You have, as I understand it, I'm going to ask you today if you can recall exactly what happened, but it's my understanding that your position all along has been this has been self-defense. A jury listened to all of the evidence and found you guilty of murder. But you basically have claimed all along that this is self-defense. As you sit here today, sober, having gone through all of the programs today, have you reflected on this crime and what your role was in this crime?
Yes, sir.
Tell me what conclusion you've come to.
I've come to the conclusion that had I not been an addict and I would have been sober, I would have never even put myself in that position to get in the altercation.
Okay. Let me ask you this. It appears that you have all along claimed self-defense. Is it fair to say that you were on drugs and alcohol that night, the day that this happened?
Yes, sir. Yes, sir.
Have you taken any sort of victim awareness courses while you've been in prison?
I took the victim awareness in the during reentry.
Okay. What conclusions have you drawn, or what have you felt towards the family of the victim in this case since you've been in prison? I mean, what would you say today?
To the victim's family?
Yeah.
What would I say? If I could go back and change things, I would. I'm so sorry. I wish that I could change my actions.
Do you accept responsibility that you, in fact, murdered someone in this case?
Yes, sir.
Ms. Hargrave, you've taken a lot of courses. I've looked at the courses. You've taken a lot of our substance abuse courses that we offer. You've taken Living in Balance, Celebrate Recovery, Thinking for a Change. You've taken Anger Management, Cage the Rage. You've taken Victim Awareness. You've taken many, many courses. Tell me what you've learned about your addiction, and what sort of plan do you have in place to be able to maintain your sobriety?
I've learned that I will always be an addict. From the day one I became an addict, I will always be an addict. And every day I'm going to have to strive to be better than I was yesterday. And I've learned that I had to learn to rethink. Just like I formed bad habits, I had to form better habits. My plan is Celebrate Recovery has been the biggest help for me. And I would like, if granted, to go out there and find a Celebrate Recovery home to belong to fellowship with them, because they've made the most impact in my life.
Have you taken any AA or NA classes, or the 12 steps important in your life at all?
They're very important in my life. I used to go to the AA, but then when I was in the reentry court program, I facilitate a residential drug abuse program. So that's like taking it daily instead of once a week.
Tell me a little bit about your disciplinary record. I think my records reflect that you've had 6 total write-ups in 20 years. Is that accurate?
I will believe so.
Okay. Your last one was in 2009. Do you remember what that was even for?
I'm not sure.
You do have law enforcement opposition. You do have obvious victim opposition. There's nothing that you can do about that. And you are low risk on our assessment, but you're high risk on substance abuse. Uh,
Yeah.
it seems like you've got a fairly good plan to maintain your sobriety. If you were to ever get released, where do AA meetings come into play for your sobriety?
Probably first and foremost. First and foremost, that would be most important of my plan.
I also noticed somewhere in your report that you've been working with the Parole Project, or you attempting to work with the Parole Project. Is that correct? Did I see that correctly?
If granted a pardon, I would like to go there and work their program and stay there.
Have you been in communication with anyone there?
Yeah, Christy Sherry.
Okay.
She said if I was granted, then they would support me.
Madam Chairman, I think that's all the questions I have at this point. I'll sit back and listen to the rest of my colleagues and the other speakers that we have to. Okay.
Thank you, Mr. Marabella. Mr. Roche has a question.
Thank you, Madam Chairman. Good morning, Ms. Hargrave. How are you?
Good morning.
Good. You told Mr. Marabella that you used a variety of drugs for an extended period of time.
Yes, sir.
Did you go to Mr. Hebert's home to borrow $300 to purchase drugs?
I went to his home to borrow $300, but it wasn't for drugs.
Okay, so it wasn't to support your drug habit.
No, sir.
Had you borrowed any money prior from Mr. Hebert?
On occasion, I had borrowed a couple of dollars, but I always paid him back.
So this was a ongoing arrangement that you could ask Mr. Hebert for money if you need to borrow some money.
Yes, sir.
Thank you, Madam Chairman.
Thank you, Mr. Roche. I don't see any other questions on the board, so I would ask staff to introduce our speakers.
Okay, first we'll hear from Ivy Mathis, friend.
Hello, good morning. Yes, my name is Ivy Mathis, and I am a friend of Dawn, and I'm here in support of her as well. I personally know Dawn because I grew up in prison. I went to prison at 17 and I was released at 43. So I know Dawn, I grew up with Dawn, and the woman that I'm looking at today that I grew up with is a woman who was always so giving of herself. Dawn was a very humbled woman, always willing to help anybody and everybody in prison whenever she was called upon. And I watched her take advantage of all the programs that was allotted to her and graduate from those programs. I have also watched her be given a high level of trust in prison to do the jobs that she was assigned to in prison. I've been home 3 years now, and if Dawn is released, I too went through the parole project. I stayed there 5 months, and what I like to do is stay connected to the women that are coming home to kind of coach them and mentor them. And I'm making a commitment in front of the board today that I will be there when she's released to help her on a successful path and journey. Thank you.
Okay, next we'll hear from the opposition, from the victim's daughter, Ms. Jacqueline Spears.
I'd like to thank the Pardon Board for letting me speak today on behalf of my father. It's very emotional because we thought we were done with this, and we received this notice on Christmas Eve as we're cooking Christmas dinner for our families that we were going to be subjected to this hearing. I'd like to say that Dawn asked for a hearing, a trial by judge. I think she knew that a jury by her peers there's no way that she would have survived that, because the photographs of what she did to my father were so gruesome. It was unbelievable. And so she chose to go through a trial by judge, and we are thankful for that, because he was able, on every item that she wrote in her description of what happened, to tell us that what was evidence that was given totally went against what she said. There was nothing that supported her version of this. She always wanted to borrow money from my dad. She threatened him when he didn't give it to her. She would attack him in public. Plenty of witnesses that show how many times she attacked him when he told her no. She called him that night to get money. He was home in bed, not bothering anybody. And when he told her no, he wasn't giving her money, she then proceeded to tell everyone in the bar where she was that she was going to my dad's house to beat him. We had plenty of witnesses. She fought with her partner, Trenda, to get the keys from her, Trenda's automobile truck, that she used to go to my dad's house to do what she said she was going to do. And so she then did what she said she was going to do, and then went back to the bar and bragged about it, which is unbelievable. We come from a small town. Everybody knows each other. My dad knew Dawn's mother, Barbara, who was a paraplegic. He helped her always. And he helped Dawn because, in a way, it was helping her. They were friends. Okay. And so what she went and did that night, no human being should ever be subjected to. A 72-year-old man, he weighed 120 pounds. Okay. They only needed one picture for the judge to see. That was the picture of his groin, where she kneed him in the groin so severely that, you know, he went down to the ground and couldn't get up. We had her own doctor witness that said that. Okay.
Ms.
Then
Spears,
she took the
Ms. Spears,
solid wood table.
Ms. Spears, can we please get you to conclude your statement, please, ma'am?
Yes.
Thank you.
And beat him with it. Okay. So I don't see any amount of time in prison that could take away the hate that she projected on my father that night, beating him so severely that every organ in his body was bruised. Okay. So no, I don't think that anybody that could do that to an elderly man with such force and hatred needs to be out in public, especially in a society where the drug use is so rampant right now, and especially in the little town that we're from. So I don't see, and my family, I'll speak for my family, we do not see that there's any type of restoration of her rights that should be granted to her today. And thank you so much for listening to me.
Thank you, Ms. Spears. Warden Thomas, is there anything you can contribute?
Hey, good morning. I think you guys covered most of Ms. Hargrave's stay with us. Obviously, she does have a very good disciplinary record, her last write-up being in 2009. I think one of her biggest positives is that she is working in our mentor program, helping ladies, you know, in the reentry court and just kind of transitioning into prison life. And I think like Mr. Marabella had said, she had quite a volume of different vocational, educational, and other programming that she's participated in. So we don't have any issues with Ms. Hargrave here at LCIW.
Okay, good. Thank you. Thank you. Ms. Hargrave, is there a statement you'd like to make to the board to wrap it up for us?
I would just like to say thank you for your time. And I'm sorry.
All right, then. Thank you. We're prepared to vote. We'll start with Mr. Marabella.
Thank you very much, Madam Chairman. Ms. Hargrave, thank you for answering my questions. I would like to say to Ms. Spears, thank you for the courage to be here today and to tell us about your father. It means a lot. Ms. Hargrave, in reviewing your file and in interviewing you, you've done a lot of very positive things while you've been in prison. You've taken some excellent programs. You have taken some of the best programs we have. You are a tutor. You are helping other women who are in prison now. The words of the warden resonate what you've accomplished while you've been in there. You seem today, at least to me, to have accepted responsibility for the crime that you committed. It's very likely to me that you may not remember everything you did because of the alcohol and the drugs that you were on at the time. You've got lots of certificates. You do have opposition. You've got law enforcement opposition. You've obviously got victim opposition. Your disciplinary record is excellent. This is a hard decision. This is a very tough decision for us to make. You've got a life sentence. You're only 50 years old. That might seem old to you, but I'm telling you, that's young. And you've served 20 years of a sentence. And to a lot of people, 20 years on a life sentence for a murder case probably isn't enough time. Considering all of those things, my vote today is going to recommend to the governor that he commute your sentence to 99 years and allow you to be parole eligible after having served 22 years. I'm going to encourage you, and one of the reasons why I want to do that is because you are making a difference to a lot of people while you are in prison. I would like to see you continue to do that. You have a high risk on the substance abuse side. You've got some good programs. I'd like to see you maybe try to take a long-term substance abuse program while you're in there. And hopefully, depending on how the rest of the vote goes, if you're able to be parole eligible at some point, maybe once you've got that behind you, the vote might be a little different. My vote today would be to commute to 99 years and make you parole eligible after serving 22 years. Thank you, Madam Chairman.
Thank you, Mr. Marabella. Mr. Roche?
Ms. Hargrave. Good morning.
Yes, sir. Good morning.
Ms. Hargrave, you have committed a serious offense. You've only served 20 years of your sentence. Even though that you have accomplished a lot in those 20 years, you have a lot of certifications, you're a mentor, you're a proctor, and you are eligible to instruct in various areas of construction. You should be commended. But I don't think 20 years is sufficient for taking an individual's life. You beat Mr. Hebert to death. The circumstances are suspect, but the fact is, he was beaten to death. You have a long history of violent offenses. You've been arrested for aggravated battery, criminal damage to property, aggravated battery of a police officer, and many other violent crimes. You have a long history of violence. You have the DA's office opposing clemency. The family is adamantly opposed to any clemency in this case. And I think you're on the right track. You're doing a lot of good while you're incarcerated, but I don't think today is the day. I think that you need to serve some additional time and keep doing what you're doing. My vote is to deny for all the reasons I've just articulated.
Thank you, Mr. Roche. Mr. Wise?
You know, I've been going over this morning. I went over it a lot last night. There's a lot of violence backing your crimes. So today I'm going to be voting to deny because of the violence and the strong victims' opposition that's in this case. I'm telling you, you're right at the edge to write back and for a date. And I just want to tell the victims today there's going to be a date when this is going to happen because she's doing real good since she's been incarcerated. But I would like for you to write back if you could.
Thank you, Mr. Wise. Ms. Jackson?
Ms. Hargrave, first, let me thank Ms. Spears for her comments as well as Ms. Mathis. We appreciate all the input we can get when we're making very difficult decisions. And so thank you both for being here to speak. Ms. Hargrave, you have accomplished a lot. You have. And you've done some good things while you're incarcerated. But when I looked at just the nature of this crime, your history of other violent offenses, your age when this occurred, you were in your 30s. You weren't a kid. You know, you were a full-grown adult. You have strong victim opposition, you have law enforcement opposition. And when I look at just the seriousness of this offense, I agree with Mr. Roche that 20 years doesn't seem to be appropriate for release. I will encourage you to continue to do the good work that you've done. Ms. Mathis is a testament to the things that you're doing, and you will have opportunity to continue to help women who need it, and I commend you for doing that. But today my vote is going to be to deny for the same reasons as Mr. Roche. Good luck to you, though.
Thank you, Ms. Jackson. So, Ms. Hargrave, you've gotten one favorable vote, but you've received 3 votes to deny your application. So today your application for clemency has been denied with the strong encouragement from everyone to reapply when you're eligible to do so and continue your community service work. Good luck to you.
Thank you.
Thanks, everyone.
You know, what it sticks out to me is Mr. Marabella asks her, "What would you say to the family?" She's like, "Say to the family? Like I would, well, if I could take it back, I would. I wish it didn't happen." It's like the classic. How is it that, like, I don't know, is it 95% of inmates, they say the same thing? Do you not? It just shows like there is no thought put into the idea that they took a loved one's life in a brutal way, that they are sitting here. Is there something that you can tell them? I wish I could take it back. I would take it back if I could. Wow, that's great. Well, I mean, wouldn't you take it back if you could? You're sitting in prison. Yeah, of course you would take it back. How about what you did? How about you express the what you did destroyed the peace in their lives, and I and how many things that one could say? How many things that one could say that would show like you actually thought about it versus I wish I could take it back. If I could change it, I would. It's remarkable. I'm just so angry at the whoever's running the board at this time behind the scenes cutting off the victim. It's like there's not 10 people speaking. Let her speak. She's waited 20 years to make a statement. Let her make the statement. It's not like she's rambling on, she was saying something. It's so disturbing, And then if you want to stop them, you can say it in a way that is respectful. You can say it in a way that has empathy, but they don't do it. Something's very wrong with the culture of the parole board management. I don't know what you want to call it. How do I remove this sidebar? I guess I can't. So facts of the case. Thank you, Richard, for providing this. On July 26, 2002, the defendant was at a bar in Kaplan with a friend. Defendant left the bar. Defendant admitted in a statement to the investigating officers that she went to J.D. Herbert's residence to borrow money from him. When the defendant returned to the bar, she was bleeding, had cuts on her face, and an injury to one eye. Pat drove her first to the Abram Kaplan Memorial Hospital and later to Lafayette General. Meanwhile, at about 9:30 p.m., Herbert was 73 years old, telephoned one of his daughters, Ellen Bufford, who lived next door. She went to his house and found him bloodied and swelling on his head and complaining of pain. He was doubled over, holding his abdomen and complaining of a strong urge to urinate. Since Herbert seemed to be in severe pain, his daughter called an ambulance and the sheriff's department. Herbert arrived at Abram Memorial Hospital at approximately 11 p.m. Bufford called her brother Joseph and also drove to his father's residence and saw his injuries. He noticed that the residence was in disarray. The first deputy on the scene was Allen, and he observed that Herbert was bleeding from his head and had wounds on his arms. Herbert spoke but was incoherent at times. The deputy also noticed the room was in disarray and that there was a significant amount of blood spatter. Herbert was later airlifted. What time did they call? 11 p.m. So I guess he was unconscious. Look at the time of the events, how long it took for him to get to a hospital. I guess it doesn't say what time she got there, but at 9:30 p.m. he called, and then 11 p.m. he got to the hospital, an hour and a half. Bufford called her brother Joseph, who also drove to the father's residence, saw the injuries. He noticed the residence was sorry, I just skipped that. Okay. Herbert was later airlifted from Abram Kaplan Memorial Hospital to Our Lady of Lourdes Hospital, where the staff performed a hernia operation. Herbert's health appeared to improve at first, but then deteriorated and he died August 2nd, 2002. It was later determined to be the head injury he received. Wow. So I guess he had internal bleeding. I don't know. On September 19, 2002, the state filed a bill of indictment charging the defendant with first-degree murder. In October 2002, she entered a plea of not guilty and not guilty by reasons of insanity. I love that defense, right? On December 11th, 2002, the state amended the charge to second-degree murder. The court appointed a sanity commission on December 19th, 2002. The defendant was arraigned on April 23rd, 2003 on the amended charge and again entered a plea not guilty by reasons of insanity. On July 16th, 2003, the court determined the defendant was competent to stand trial. Defendant waived her right to trial by jury. She waived her right to trial by jury. Okay. Like a judge is really going to help you out here. On January 25th and 26th, the court conducted a bench trial and found the defendant guilty as charged, and she was sentenced to a mandatory term of life imprisonment. On February 24, 2005, the defendant now appeals. And defendant concedes that she pushed the victim and kicked him in his testicles. She also stated that the victim fell against a TV stand. However, she argues that she was defending herself from sexual advances by the victim. Defendant did not testify by her statement to police, but her statement to police was introduced at trial. In this statement, she claimed she went to the victim's residence to borrow some money. According to the defendant, she used the restroom, and when she came out, the victim was nude. He then tried to force himself on her, but she pushed him away. The defendant claimed the victim then poked her eye with some object, then tried to force her head towards his genitalia. She then kicked him in the groin. He fell, and she left the residence. The defendant, not the state, has a burden to prove on defense of the manslaughter. Defendant was established by a preponderance of the evidence, and the homicide was committed in sudden passion, heat of blood. Jurors erred in finding the defendant guilty of second degree. This being said, the jury in this case could believe it is disbelief the version related by the defendant. Police officer's failure to find manslaughter is not reversible error. It is interesting. You would think that this could have been easily a manslaughter case. Because the victim ultimately died from the injuries received in the incident, the homicide standards applied here. However, the force used by the defendant was not reasonable under either standard. The events described by the defendant in their statement do not indicate the need for deadly force, infliction of great bodily harm. Even had the victim survived, the force used on him could not be described as reasonable or necessary. And the truth is, if he did survive, she probably would have gotten a rather light sentence. I mean, because he was airlifted, I'm sure they would have thrown the book at her, but it still would have been relatively light, I'm guessing. The victim's daughter and son and deputy called the scene. All described the victim as bloody. The victim had an obvious injury to the head and defensive wounds on his arms. Yeah, it's not what she just said, right? I mean, she said she kicked him once and pushed him. And it seems clear that she beat him. The medical evidence demonstrated that he had been beaten head to toe. The victim was a small man, 5'6" and 140 pounds. I thought the testimony today was 120 pounds, but close enough, right? As the defendant, trial counsel acknowledged the victim was a frail old man. Pratt stated that the victim frequently made passes at her, but acknowledged that he was easily repelled because there was nothing to him. Defendant's height and weight are not in the record, but she was apparently in her mid-30s, much younger than the victim. The testimony also indicated that she was a capable fighter and had battered the victim in a barroom prior to the offense at this issue. Wow, they had a real great relationship going, huh? Baines Richard, an acquaintance of both the victim and the defendant, testified that he saw her cold cock. What is that? The elderly man at Kaplan bar called Rumors, knocking him from a stool. I guess that means like a sucker punch. According to Richard, the incident occurred approximately 6 months before the offense at issue. Pratt testified that a few months before the offense at issue, while at Rumors, she saw the defendant grab the oh, look at this. The measurement listed from the pathology testimony. The victim's daughter described him as 5 feet 9 inches and weighing 120 pounds. Look at that. She's, oh, look at that. Yeah, he was right. She used the same testimony today. While at Rumors, she saw the defendant grab the elderly victim by the neck and throw him under a pool table. It is not clear whether the two witnesses were describing two separate incidents or two versions of the same incident. In either case, the evidence shows the defendant had the ability to physically dominate the victim and was aware that she could do so prior to the offense at issue. Richard and Pratt both testified the dispute or disputes centered around money the victim had lent the defendant or Pratt. The record demonstrates the defendant had little to fear from the frail elderly victim. Even if it became necessary for her to physically repel him, the force she used was clearly excessive. Dr. Emil Lega, the forensic pathologist who examined the victim's body, noted multiple external injuries, including a 3 to 4 inch bruise on the left temple area of the head, extending behind the ear towards the back of the head, 3 lacerations on the left upper eyelid, below the left eye, and the left ear. Injuries to his legs, including 2 bruises on the lower left leg and 1 on the right, a deep cut over his right knee, injuries to the groin, and a 4-inch bruise on the left buttock. She like really gave him, man. Dr. Lega agreed that the victim was beaten from head to toe with the major injuries on the left side of the body. He opined that the injuries may have been inflicted by hitting him with the wooden TV tray, which was found at his residence. Given her history of physically dominating the victim, even the defense's versions of events does not depict a scenario in which she could reasonably have believed that she was in danger of death or great bodily harm, or one that called for her to inflict great bodily harm or death on to defend herself. Defendant further suggests that the evidence does not satisfy requirements of the due process because fingerprints were not lifted from the wooden TV tray that may have been used in the offense. Blood splatter was not analyzed for DNA at the scene, was left unsecured and unprocessed until August 2nd, 2002, and as court has previously stated. Well, they apparently did a pretty awful job on that crime scene. I could see in this day and age, while they would bring in they would call her a battered woman. They would call her, they would paint this whole picture about how he was always advancing on her, and she goes to the bathroom and she comes out and he's naked and she just loses it. And I could see a jury giving her manslaughter or some type of, but, and they probably weren't allowed to bring in her previous records, and I don't think they were. They only were allowed to bring in the previous fight she had with him. So without the jury knowing, I could definitely have seen this go a different way. But I'm not saying she deserves it. It seems, I mean, she probably did clearly snap. But that still makes her dangerous, right? I mean, who knows when she's gonna snap and rage on a man that she knows that she can dominate, as they said. It's like, it's about protecting, it's about the victims, but it's also about protecting the next potential victim. It's what do you feel? Do you feel that she shouldn't have gotten the second degree murder? It should have been manslaughter. She could have been finishing up her sentence by now, not needing a commutation. Remember, she got life without the chance of parole. So this was a commutation hearing. I would argue that life is a bit excessive for this kind of case. But then again, you look at all of her priors and she seems like a loose cannon, dangerous. I don't know. You tell me. With that,
A commutation of your sentence. You were sentenced for a first-degree murder conviction in Tangipahoa Parish in 1978. Originally, you were given the death sentence. You were resentenced in 1982 to life without parole. Mr. Miles, is that information correct?
Yes, ma'am.
All right, thank you. Would you answer Ms. Jackson's questions, please?
Yes, ma'am.
Good afternoon, Mr. Miles. How are you doing today?
Doing good. Good, ma'am.
My name is Bonnie Jackson. Your case has been assigned to me, so I'll start off the questioning for the board. So I just want you to relax and we can discuss some things, all right?
Right.
How old are you, Mr. Miles?
69.
And how much time have you served in prison on this crime?
You mean, I got arrested in 1977, December 26 or 27, something like that.
So you've been incarcerated continually since 1977?
Yes, ma'am.
Is that about 44 years?
44 years and some months. Yeah.
Okay. And you were in your 40s when this, how old were you when this crime occurred? I'm sorry.
25. 25.
25.
Yes.
Now, I have to just say right off the bat that this was really an awful, awful crime.
Yes, ma'am.
I mean, really awful. This, older woman was killed during an armed robbery. She was severely beaten and she was also shot in the head. And you only got about $60 from that robbery.
Right.
So explain to us why this happened. What caused you to commit such an awful crime?
I can't believe that's not my character. I can't believe that, I did something. For years and years, I've been trying to, come to grips with it. I just can't believe I did it. But all I know is I was at this West End bar and having a drink with a guy. When I step out the place, it's like something that's grabbed me, took a hold of me, and voices and stuff, and
What kind of voices?
it was just like spiritual voices that I couldn't see, but I could hear them, and I could feel like overwhelming presence that's pulling me, and
Well, had you ever heard those voices before or had that experience before?
No, ma'am. I had.
What about since then?
Yeah, since then I've heard on the spiritual level, I heard folks. I even hear people pray sometimes.
Have you ever been diagnosed with any kind of mental illness?
No, I've had some treatment, but
Treatment for what? Tell me what you had treatment for.
not prior to my sentence.
I mean, since you've been incarcerated, have you been diagnosed with suffering from any kind of mental illness?
No, maybe I have dealing with psychiatrists, but nothing really serious.
Did they put you on any kind of medication?
No psychotic medicine.
Okay. And do you still see a psychiatrist?
I think everyone is assigned to a social worker.
But you don't see a psychiatrist on a regular basis?
No.
Well, one of the things that I heard you say was this was not in your character, but I do see that when you were 16 years old, you were arrested in connection with burglarizing a couple's home. And during the course of the burglary, you tried to rape the wife and you ended up pleading guilty. And you got 7.5 years when you were 16 years old. Is that correct?
Yes, I was 15, but I made a plea bargain without a lawyer, and my lawyer finally said that this, I couldn't. As a juvenile, I was supposed to go to juvenile court, not criminal court. So
I understand that. I'm not so much interested in the legal proceeding as I am about the facts of the case,
right,
because those are also very bad facts.
right,
So we've got two cases where the crimes that you committed were really, really awful crimes.
right.
So how can this board feel comfortable with releasing someone who has that kind of history or background? What would you
Well,
say to that?
Well, I would say I would be skeptic over myself for releasing someone like that. But I've come to the point where all that's behind me, and I want to. Everything is new, I want to do something better. I've done a lot of bad things in my life, and I just want to do something good before I die, that's all.
Well, tell us about, what kind of programs have you taken while you've been incarcerated?
What that, substance abuse, anger management, faith-based programs and stuff like that. Basically, programs that helped me mentally. When I got sentenced, the judge told me that the only help that I would get would help myself, and that's what I've been doing, trying to help myself.
I see you took Cage Your Rage. You remember taking that?
Yes, ma'am.
Living in Balance.
Yes, ma'am.
What kind of substance abuse programs did you take? Because I didn't see them listed.
I took one here at Hunts and one at Angola. I took the Valerie Oliver, social worker, and I forget the social worker name here at Hunts, but I took it twice.
Okay, but what did it involve?
Showing the danger of different drugs, and how to stay strong and stay away, and how to ask for help if you need it, stuff like that.
Well, you haven't taken a whole lot of programs over the last 44 years. Why is that?
I don't know, like what type of programs?
Well, I mean, they offer all kinds of programs within DOC, and I don't, the only ones I've really seen you take, besides faith-based, are Cage Your Rage, Living in Balance, and I did see you took a course on end-of-life patient care.
Yeah. Yeah, I took that. I'm still in that, but due to the pandemic,
Well, what's your job? Do you have a job at the prison? What do you do there?
Patient care.
Okay, how long have you been doing that?
About 10 years.
And what does that involve? What do you do in patient care?
Take care of the patient. Basically, take care of patients that are unable to help themselves, whatever they need.
Is it like hospice care, or is it just?
It's not unlike hospice. It's similar to hospice care. Basically, they work hand in hand.
Okay, and you've been doing that for about 10 years?
Yeah, 10 years maybe.
And how long have you been at Hunt?
Going on 11 years or something like that.
And you were at Angola prior to that?
About 34 years.
I see you have a niece on the screen, but do you have any other family living?
All my brothers and sisters died since I've been incarcerated. And my father killed my mother when I was 2 years old. So I got some maybe nieces and nephews. That's all.
But you didn't have any children of your own.
No, ma'am.
Do you have any job skills?
No, I've been to a lot of different mechanic school, butchering school, and stuff like that, but I didn't complete them because if you like, when I was going through the program, like if you get a write-up, you would get cut out of this class so somebody else could go to class, because you know.
So how many write-ups do you think you've had?
Well, I have maybe 60 or 70. I'm not sure. I used to try to calculate it. I mean, I would average like a year, 2 or 3 a year, something like that, but I lost.
Do you know when was the last write-up that you had?
I would think about 5 years.
And what was that for?
They refusing a urine test, urinalysis test.
You refused it?
Yeah.
Why'd you refuse it?
Those,
Would you have been dirty for some substance?
well, I doubt it. But one time I felt like I was set up, that I had a urine test that I knew I wasn't dirty, but they claimed me dirty. And so I said I would never take another, but after I went to the block on that charge, I had to take them like every month, something like that, every month, and pay for the cups, something like that. But I said I would never take another, but I took them, you know.
All right, is there anything that the staff at Hunt can tell us about Mr. Miles?
It probably tell
No, I'm asking them. I'm not asking you, I'm asking them.
I got you. Just like he said, upon his transfer here, when I was looking back, he has been, I didn't know how long, but he has been working in the skilled nursing unit as a patient care orderly 14 years. And that is a testament to him. I mean, it's a sensitive area, and it is some hard work that it's hard to find good workers. So, I mean, that is to be commended. And I do have comments from the major who supervised that area and Lieutenant Colonel, who recently was assigned. They have favorable performance evaluations for Mr. Miles. He's I've seen him around for years, but he's pretty quiet. So that's all. I mean, I don't personally know him, but I've seen him in that skilled nursing unit. And we don't have hospice, but it's synonymous. It's end of life care, and he definitely does a good job over there.
All right. Well, thank you very much, Ms. Renata. That's all I have.
Thank you. I think we have some new guests that have joined us. I'll let the staff introduce them, and then if you would call on those who indicated they'd like to speak to Ms. Roten.
Yes, ma'am. Just joining us today, for the record, we have Ms. Joyce Rollins, the victim's niece, who will be speaking in opposition. She's been joined by 2 BACs from Tangipahoa, Ms. Tamika White and Rachel Dykes. Neither of whom will be speaking today. First, we're going to hear from Ms. Nancy Goodwin, the friend, and she's in support. Ms. Nancy.
Thank you. I met Elvin Miles in approximately 1981. I met him in the capacity as a paralegal who was helping defense attorneys find mitigating circumstances for death penalty cases. I was at his, I assisted Mr. John Reed at his second penalty phase. I'm very familiar with the case. I have more information I could give you about certain things, including the charge as a teenager that, but I eventually left that particular position. I got married, started a family. It was not something I wanted to continue at that time. I stayed in touch with a few people I had met, and many more prisoners tried to stay in touch with me. And I disengaged from almost all of them, and eventually all of them, except for Elvin. And that was because I felt there was something different about him, that he was in some way capable of a lot more. And I also sensed that he did not and had not had as much education in a spiritual sense. He is capable of reading and understanding quite a bit. And I will say that he's rather shy, but once you get to know him, he can speak intelligently on a number of subjects. And I introduced him to books like Viktor Frankl's Man's Search for Meaning. He was always in trying to make sense of what happened, how he got that way, how he could do better. He had a lot of anger that he had to deal with about a number of things, beginning, I think, with the fact that he was with his mother's murder, and the fact his father never showed any remorse for it. And he had a lot of the kinds of complications that psychologists see in children with unresolved grief issues into adulthood. There are a number of things that's impressed me about Elvin. First of all, I think of all the inmates that I knew, and some of them continued to know for a while, he is one of only two that never asked me for anything. He never asked me for money. I felt he was very honest. He was
Ms.
always
Goodwin,
very,
Ms.
yes,
Goodwin, excuse me, can we get you to conclude your statement, please?
yes,
Thank
okay.
you.
Briefly, I think the job at hospice, the hospice care that he's doing, has given him the chance that he needed to finally understand himself better, develop himself spiritually. He cares about that job. He is, I believe, genuinely repentant. That's why I am here. I didn't attend some of his earlier pardon board hearings. I believe that he has developed more insight. I believe he's remorseful. I believe he finds a great deal of atonement and satisfaction in thinking he is now doing something constructive. And I believe that if he were released tomorrow, he would live a quiet life with his
Thank you,
remaining
Ms. Goodwin.
family.
We're going to move on to Ms. Deborah Wilson now, please. Thank you. Ms. Wilson, we need you to unmute your mic, please.
Hello.
Yes, ma'am. You can make your statement now, please.
Yes, I'm Deborah Wilson. I'm his niece. My mother was his sister, and I've been coming to see him when he was in Angola and at Hunt's. And my brother died in September of last year. We've been staying close in his life, and I just wanted to reassure him that if he come home, all us gonna help do whatever we can to make him have a good Christian life. We all go to church, we work. I usually do gardening and mess with flowers, but I know I can find him something to keep him busy and keep his mind occupied. And he have nieces that's nurses, and he have one nephew that's a police officer, and we all untalked. And we hoping that he can get out so we can spend some time with him, because all our parents are dead.
Thank you, Ms. Wilson. Now we'll hear from the opposition side from Ms. Joyce Rollins, the victim's niece.
Before I begin, I would like to let the board know how much the family of Lucille LaMonica Erickson appreciates the opportunity to express our vehement opposition to Elvin Bo Miles's application for clemency. I am Joyce LaMonica Rollins, niece of Mrs. Erickson, who lived next door to me until the day that she was murdered by Miles. I am accompanied by my husband, John Rollins, but before I begin, I would like to present a petition signed by 127 people or the remaining family and friends of Mrs. Erickson. A copy of that was emailed back on February the 2nd. In case you aren't in possession of it, I have the pages here and would be happy to either mail or re-email this after the hearing is done. I'd like to start out by saying that my family will always recall Tuesday, December the 27th of 1977 vividly. Christmas had been on a Sunday that year, and most businesses and agencies were closed that Monday in observance of the holiday. That Tuesday morning, things resumed as usual with everyone ready to celebrate the incoming new year. But by that evening, however, something would occur that would cause our family to bring in the new year grieving, not celebrating. For at around 5 p.m. on that day, Elvin Bo Miles walked into Silton's department store in Amite, Louisiana, pulled out a gun, and proceeded to pistol whip and murder my aunt, Mrs. Erickson. She was a 68-year-old widow who had to work at Silton's department store to supplement her meager income so she could afford the bare necessities. As members of the board, I'm sure you have extensively probed Miles's criminal record and have been able to ascertain from what you've read that he has a protracted history of rage and proclivity for violent criminal behavior at a very early age. And his criminal career continued until he was arrested for the murder of my aunt. Miles could obviously see when he walked into Silton's department store that day that Mrs. Erickson was physically incapacitated because of an injury that she had sustained months earlier. She was in constant pain and walked with a limp, yet he dragged her into the bathroom where he pistol whipped her and shot her twice, once directly into the top of the head and once into the eye. I'm not sure how clear this picture is to you, but this was filed in state's evidence at the April 24th, 1978 trial. According to the statement of the attending physician at Hood Memorial Hospital made by Dr. Thomas Evans, where my aunt was taken after the incident, Dr. Evans reported that wounds to Mrs. Erickson's head were so severe that it indicated a brutal beating by the defendant with the firearm. Dr. Evans reported that the victim's head felt like a bruised cantaloupe. Evidence that Miles felt no remorse for his actions and that he in fact found humor in what he did was demonstrated by the fact that he made a statement later that evening. Within a few hours after having brutalized and murdered my aunt, he partied at a Hammond hotel with some of his cohorts. While they partied, he laughingly conveyed that Mrs. Erickson jerked like a chicken when he shot her. This testimony was given by Jackie Hickerson, who served as a witness for the prosecution. Not only had he taken her life, but he continued to desecrate and defile her and strip her of any dignity by making fun of her and the atrocities she suffered at his hand. I had the opportunity to talk with a neurosurgeon years later about this testimony, and the doctor indicated that while Miles's description of what he saw was primitive and vulgar, it was accurate. Miles was actually describing the convulsions that my Aunt Lou suffered due to the brain trauma, the trauma resulting from the severe repetitious blows and the 2 gunshot wounds to her head. Miles did something else which demonstrated his sociopathic nature.
Ms. Rollins, excuse me, Ms. Rollins, due to time constraints today, can we please ask you to conclude your statement for us?
Yes, ma'am.
Thank you, thank you.
Ms. Goodwin talks about how he's changed and how he's found peace working at his job in the infirmary. Well, that's where he needs to continue to be. We have a right as citizens to live in our homes, to be in our workplaces, to be in our cars without being victimized by people like Miles. He hasn't changed and he's never expressed any remorse for what he's done. I am asking the board to please consider our petition not to grant him clemency.
Thank you, Ms. Rollins. Mr. Miles, is there a brief statement you'd like to make to the board to wrap it up? If you have a statement, address your remarks to the board.
Well, I would like to say, God bless Miss Erickson's family, and I hope they find peace someday, you know. And I give my everything to God, and that's all I could do. And you know, that's all I could do. I can't bring Miss Erickson back. I can't take their pain away, and it's always going to be like this. So you know. What can I say? But by the same token, everything she said that I did, no one was there. No one seen this. You know, I said this. You know, so you should understand that if I'm not trying to hide this, I'm telling them what's happening. They should understand that I was sick. I was, you know. It wasn't nothing that I was trying to, you know, I needed help. I didn't know what to do, that's all. And like I said, God bless them and may they find peace. That's all.
Thank you, sir. Thank you, sir. I think we're prepared to vote. We'll start with Ms. Jackson.
Mr. Miles, yeah, this is an extremely difficult case. It really is. The facts of the crime are really horrible. We've already talked about that. As a juvenile, you had a really horrible crime as well. I have some concerns about mental health issues, particularly in your accounting of how this happened or what caused this to happen or what made you do this. I'm concerned about your disciplinary write-up history. I'm concerned that, you know, you refused to take a urine test. Your belief that somehow you were being set up may indicate some level of paranoia. I don't know, to what extent you've undergone a psychological evaluation while you're in Hunt. But I have some real concerns about you. I know you're 69 years old and you've been in prison for 44 years, and that's a long time. But on the other hand, I don't see that you've taken a whole lot of programs that would help you successfully transition back into the community. You have adamant opposition from the victims as well as the community where this occurred. And today, I'm just not prepared to say that I feel like you've done enough or you're ready to be released back into society. I really appreciate the work that you're doing with the end of life patients. That's important. It really is important when people are in prison and they're dying, to have someone there who takes good care of them and shows them compassion. And I really appreciate that you do that. But today, I just have a level of discomfort that doesn't allow me to vote for you today. So my vote today would be to deny your application because of your disciplinary history and strong victim opposition and lack of programming. But keep working and keep doing the good that you're doing where you are. But that's my vote.
Thank you, Ms. Jackson. Mr. Marabella?
Thank you, Madam Chairman. Mr. Miles, Ms. Jackson is correct. This is a very, very difficult case. And, the facts of the case are horrible. And my heart goes out to Ms. Erickson's family and all of the things that I've heard today. But we're not here to judge you on what you did. We're here to judge you on what you've become and who you are today. And I have some real concerns about that. I agree with Ms. Jackson. I think there may be some mental issues here that need to be addressed. You haven't taken very many productive programs that might be helpful to you. You've worked hard while you've been in prison. There's no question of that. But I feel that my responsibility is to look at all of the facts and make sure that society is protected if we were to release you. And I'm not sure I feel that way today. I can't say, as Ms. Jackson pointed out, I just don't think I can vote today to recommend to the governor that he commute your sentence. So my vote today is likewise to deny. I want to encourage you to keep working hard, and perhaps in the future that might change, but not today.
Thank you, Mr. Marabella. Mr. Roche?
Thank you, Madam Chairman. Mr. Miles, I'd like to echo every statement, every observation that my two colleagues have mentioned. And I just don't think you've had enough programming. You have tons of expressed opposition, not only from the victim's family, from the entire legal community. And I don't see the rehabilitation because you just have not made yourself available to the programs. For that reason, my vote is the same, to deny your request.
Thank you, Mr. Roche. Mr. Wise?
At this time, I'm gonna be voting to deny. One of the reasons I'm voting to deny, very strong law enforcement opposition, victims opposition, your criminal history. In 1978, you were sentenced to a death sentence. In 82, it was overturned to the Supreme Court. I think you need some more proof. My vote is to deny.
Thank you, Mr. Wise. So, Mr. Mize, you've received 4 votes to deny your application for clemency. So today, your application for clemency has been denied. Thank you, everyone, for your participation today. Warden Gayrian, I think that concludes our business at your facility. It is 1:22, and we shall stand adjourned. Thank you, sir.
Yes, ma'am. Thank you.
I'm really glad that Jim Wise brought up the fact that he was given the death sentence and it was overturned, and we'll go over why it was overturned in a little bit. Thank you, Richard, for providing the info. But why it's so timely is that I don't know if you've seen some of the cases that we've seen, the death sentence cases that we've seen recently. There's a whole thing in Louisiana where the governor tried to get almost everyone off of death row to commute their sentence from death row so they can be in general population but still have a life sentence. And in those hearings, we saw pretty much almost every time the attorney or someone else say, we are only trying to get them from death row to life sentence. They will never step free. And that's not true. Now, we have had the board members state it's not true. We have had the DAs come and state it's not true. And we have said it's not true because we have seen people moved, like in this case, from death row, where their sentence is then changed to life in prison. And here he is with a chance, another bite of the apple, as Mr. O'Shea says, and a chance of being set free. And I just wanted to point that out because it really angers me when the support for these people who were given death sentences come up and speak on these I am higher than thou stature and way they hold themselves, and then they would come up and blatantly lie. So here's this on the record. Second, what is wrong with the support of this man? They should be, this man, he should be in a mental asylum. I don't know, but certainly his support, I think, should be in there with him because he just came here at his commutation hearing, and his reason for committing these crimes was because a spiritual voice came and spoke to him. That's how he described it, as a spiritual voice, not an evil voice, but a spiritual one. And then he goes on to say that he still hears those voices. How can you get up there and ask the board to release someone who claims to hear voices still, and use those reasons for why he beat and killed an elderly disabled woman? You have to be mad. We see, it is bizarre, but such a large percentage of people that come up in support seem to be a little bit off. It's the strangest thing. I can't put my finger on it. There are we do occasionally see support that do not fall under that umbrella, but oftentimes we do. And I mean, there was the one woman there that it looked like, I don't know if she has herself some issues, and normally I don't comment on these things, but it looked like she was talking to the camera the entire time. Even at the end there, it looked like she was yelling at it was just kind of, I don't. Then his final statement. He never said sorry once. I mean, not that I would care if he said sorry, it would mean nothing to me, but the fact that he didn't even say it, God bless their family. I hope they find peace. Which is okay. That's okay to say, actually. But then he says, I can't bring her back, which they often say. And then he goes on to say, but I need to tell her that no one's seen me do it. No one even knows what they're saying. I didn't, only I know what I did. And it's like, what? What are you talking about? And that was pretty much it for the final statement. Not I'm sorry, not this, this it pains me, not I regret, not nothing. Again, not that it would make a difference, but he starts with Miss Jackson. This was totally out of my character. I've never done anything like this. I was not possessed. I heard voices, spiritual voices. And she's like, well, you had the burglary where you attempted to sexually assault the wife. Oh, whoops. Didn't know Miss Jackson would do her homework, huh? Thought you could just pull a fast one over. So here's the information of the case, right? Also, the reason that he got this overturned by Supreme Court ruling was quite interesting, and I'll tell you why. I think it's quite interesting, but well, okay, first let's go into what they said. So at about 4:45 p.m. on December 27th, so it's actually one day before. I'm recording this on December 28th, right? So as the victims mentioned, their New Year's, right? And right after Christmas. Elvin Miles entered Silton's department store in Louisiana. After browsing for a short time, he grabbed the store clerk, 68-year-old Miss Lucille, and ordered her to open the safe. When she replied that the safe could not be opened until the manager returned at 5, Miles forced her into a dressing room in the rear, which is only 15 minutes, by the way. Like he couldn't wait. In the rear of the store and shot her twice in the head while she was seated on the toilet. He then emptied the cash register and took 2 coats, 2 sweaters. Miss Eggerson was found a few minutes later by her sister and a neighbor and died that evening. Upon leaving the store, Miles met an acquaintance, Dexter, and explained the blood on his hands by telling Leonard that he had been caught shoplifting and had been shot by a store clerk. Wow, great story there. Leonard and Miles then went to Lorraine's White's house trailer while Miles waited while Leonard secured change of clothes for him and threw his old clothes into an abandoned van behind the trailer. Later that evening, Lorraine White and Natalie Lindsay drove Miles to Hammond to catch a bus to New Orleans. However, Miles changed his plans while waiting for the bus and decided to stay at a motel in Hammond for a few days. After Lorraine White rented a room for him at the Magnolia Inn, she drove with Natalie and Jackie to Arcola, Louisiana, where Miss Hickerson threw a paper bag containing the murder weapon into the river. The 3 women then went to Miles' room where he entertained them by relating the circumstances of the murder. It's so insane. It's like we see these cases all the time where they then throw it. It's like, really? You got what, $68? You could have sold your gun. No, go get $68 and then throw your gun away. Ridiculous. Miles was arrested on the following day and confessed. Miles was arrested the following day and confessed to the crime in the late afternoon. He was indicted on January 4th, 1978 for the first-degree murder, and after motion to suppress the confession was denied. The defendant was tried and convicted as charged. The jury thereafter found the presence of one aggravating circumstance, that the murder had been committed during the perpetration of an armed robbery, and consequently recommended that the defendant be sentenced to death. This is kind of bizarre to me, that the aggravating circumstance is that it was a capital murder, they're stealing, and that makes it a murder offense, not the idea that it was completely unnecessary, not the idea that, it's just weird how the law is written, right? That's just pretty bizarre to me. On May 11, 1978, Miles was sentenced by court in accordance with the jury's recommendation. Now the defendant appeals. And we're not going to go through all of it, but he gave different reasons for the appeal, and one of the reasons was inefficient counsel. And right, is that the word? Or insufficient counsel, inefficient counsel. And we see that all the time. It's like it's Hail Mary, grasp at anything. And in this case, the Supreme Court ruled that the counsel did blow, basically, and we'll go over why. And they overturned the death penalty. Applying the standard, we conclude that the admissions by defendant's counsel established that the assistance afforded by his sentencing hearing was constitutionally inadequate. The advocacy for Miles' life was tepid and virtually non-existent. In his closing argument, the defense counsel did little more than acknowledge the existence of an aggravating circumstance, state that the confession may be regarded as a mitigating circumstance, and submit the matter to the jury. He did not ask the jury to spare the defendant's life. He did not remind the jury that Elvin Miles is a human being or urge the jurors to be mindful of the awesome responsibility in deliberately choosing whether he should live or die. Nor did he emphasize to the jurors any of their legal obligations designed to prevent the arbitrary or capricious imposition of the death penalty. Example, the requirements that they base their findings upon a beyond a reasonable doubt certainty, their duty to weigh any aggravating circumstance found against any and all mitigating circumstances, the duty of each individual juror to hold fast to his honest conviction and to vote to prevent a unanimous verdict in the event he is convinced that the death penalty is inappropriate. Moreover, the defense attorney's lackluster argument followed his submission of the case for his client's life without evidence. We cannot say that the counsel acted unreasonably in deciding not to present any evidence, although the sentencing report reveals that some mitigating evidence consisting of severely deprived childhood resulting from the death of his mother at the hand of his father. Oh, right, that he did mention that, right? Yeah, for sure. I mean, that is something you would definitely bring up. The countervailing evidence of Miles' antisocial character and propensities was substantial. Having rested his client's case without evidence, however, it was even more imperative that the defense counsel advocate his client's cause in closing arguments. This practice of law is a partisan endeavor requiring those who engage in it to represent the client vigorously, even in the face of overwhelming adversity. The attorney's closing argument, amounting to little more than a mechanical submission of the defense's fate to the decision-making process with no attempt to influence it, definitely fell below the minimum standard of competency constitutionally required. The failure to make a closing argument or make one which is clearly perfunctory has been found to constitute ineffective assistance. That's what it was, ineffective assistance of counsel. The court does not sit to second-guess strategic and tactical choices made by trial counsel. We are aware that understatement and deliberate omissions may be sometimes based on the informed tactical judgment. However, when counsel acts that omissions reduce his role to the one approaching that of neutral observer, a defendant is denied the effective assistance of counsel. For the foregoing reasons, it is clear in the record that before this, the petitioner did not receive the effective assistance of counsel to which he was entitled under the Constitution. The sentence of death must be vacated and the case remanded to the trial court for new sentencing hearing, at which the defendant shall be represented by newly assigned counsel. Now, it's not clear to me. Here, they say she was 86. I thought they said she was younger. She was 86. It's not clear to me if they had a second trial or if they just let it go. Sentencing trial. A lawyer's obligation to see the defendant gets a fair trial, and the most any lawyer can do in this case is rest the presumption of innocence and have the prosecution's feet and hold the prosecution's feet to the fire. trying to see, is this redundant? He did not remind the jury the defendant was a human being, or remind them it was Osborne. Yeah, this seems redundant. But anyways, it was overturned, and I don't know if they had another trial or they just settled for life, like another sentencing hearing. This was only for the sentencing, right? Not for the guilt. But yeah, that attorney obviously sucked. It seemed almost, I'm sure he would have left the jury with the impression of he doesn't care, you know? But what I was thinking is, I wonder if that even could be a strategy of an attorney to be like, I just will do a really, really, really bad job so it can get overturned on appeal. I mean, I doubt it. You would think that any self-respecting attorney, but on the flip side, how can you be a self-respecting attorney and not do any of those things for your client? It's like, if you're that burnt out and you're that exhausted and you just don't care, then you shouldn't have this. This is not the job for you. You're not a public defender for the money. So you're doing it obviously for other reasons. And if you're going to have the Supreme Court overrule the sentence, I mean, that's got to be a crummy feeling. That's kind of like, it's time to check out because you've already checked out. Time to retire. But man, this was a very clear-cut, easy to say case that this man should never, ever be out. And the idea that people could support him is just terrifying, because he's going to get voices in his head now. Like, you're going to have him stay in your house with you, and then what? You don't think he might? I mean, well, maybe I'll kill you. Why would that not cross your mind as not just a possibility, but maybe even a high likelihood of occurring? But there you have it. You probably wouldn't believe it if you didn't see it, but there you go. And with that, I'll let you go.